Zero is a waiver.
to circuit court.
And who's the other person?
Felony.
You know who's the waiver?
Believe it to be Melvin Benson, but won't start its own.
Oh, okay, sounds good. On the record in the matter of the people of the state of Michigan versus Daniel Darrow Jr., file number 22-01915 FY, council appearance.
Chris Martin for the people.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Darrow, who appears today from the King County Jail.
Thank you, Mr. Darrow. Can you hear me?
Yes, ma'am.
Okay, excellent. Today's the date that was set for probable cause conference. My understanding is that there's an unconditional waiver to the circuit court. Is that correct?
That's correct, Your Honor.
That's correct, Your Honor.
Okay, was there an offer on this?
There is, Your Honor, and it's, not much of an offer at this point, but he has some pending matters in circuit court. The plan is to come up with a global resolution. And Mr. Darrow has previously been found to be eligible for Veterans Court. So our hope is that we can reach a final resolution with Veterans Court.
Okay, and Mr. Darrow, do you understand that you have the right to have a preliminary examination here in the district court?
Yes, Your Honor.
You understand that at the time of the examination, you have the right to have the prosecution bring sufficient evidence to meet their burden. They have to establish that there's sufficient probable cause that a crime was committed and sufficient probable cause to charge you with that crime. You understand that?
Yes, ma'am.
You wish to unconditionally waive your right to exam today?
Yes, ma'am.
Okay, so the unconditional portion means that once you waive it, it's gone. You can't come back later and say that you want to have an examination. This matter will be bound over to the circuit court, and your next court date will be a pretrial, but there'll be no hearing held here to establish probable cause. You understand that?
Yes, ma'am.
Is anybody making any promises to you to get you to waive your examination in this district court?
No, ma'am.
Okay, is anybody threatening you at all to get you to waive your right to examination?
No, ma'am.
And you're waiving your right to exam freely and voluntarily?
Yes, ma'am.
Okay, this matter will be bound over to the circuit court for a bind over date. What is today's date? First. August 10th is your bind over date. That's just the date that the circuit court gets the file from this court, okay? You do not need to appear in court on August 10th, nor will you have to be arraigned in circuit court, okay?
Yes, ma'am. Thank you.
Your next court date again will be a pretrial. Mr. Palmer will be made aware of that date. Do you have any questions at this time?
No, Your Honor.
Current bond was set at $1,000 cash. That will continue. Any additional matters for the record?
Nothing from the people. Nothing from the defense.
Thank you, Mr. Darrow. You're all set.
Thank you, Judge.
You're welcome.
Mr. Darrow, I'll be in touch.
Okay, thank you, Mr. Palmer.
Of course. Oh, yeah.
Okay, we're on the record in the matter of the people of the state of Michigan versus Jabril Hakeem McCullum. File number 22-01756. Council appearance, please.
Chris Martin for the people.
Deborah Martinez on behalf of Jabril McCollum, who is present on Zoom today, Your Honor.
Thank you. Today was the date that was set for a probable cause conference. Examination is scheduled for August 5th at 9:30. My understanding is that we need to have a 21-day waiver. Is that correct?
That's correct.
Yes, Your Honor.
What is the purpose of the waiver?
Your Honor, we have not yet received discovery. We have requested that from the Ingham County Prosecutor's Office. Additionally, I have a pre-scheduled vacation with my children next week where I'll be out of state. Hopefully we can adjourn it so Mr. McCollum can make an informed decision about how he wants to proceed, or if not, with a preliminary examination based on review of those reports, and so I can be present and fully prepared.
Okay, you said you did make a request for the discovery, you just have not received it?
Correct. And we sent a reminder email yesterday as well.
And for the record, Ms. Martinez has been very communicative with me and my office.
Yeah, I see where her appearance was filed a lease on July 20th. Because of that, I'm not going to require your client to waive his right to 21 days. I'll find good cause to adjourn it beyond the 21-day time frame due to the discovery issue, and we'll reset this matter. Okay, Mr. McCollum?
Yes, ma'am.
Okay, so for your information, you have the right to have your examination within 21 days of your arraignment date. But due to the discovery issue, then also due to the fact that your attorney is not available, I'm going to find good cause and set it beyond that date. Let's see if we can get a date now.
August 19th and 9:30.
Does August 19th work for you, Attorney Martinez?
It does, Your Honor.
Okay, we'll do August 19th at what time again?
9:30.
At 9:30.
Is that the probable cause conference or the preliminary examination?
Did you need another PCC?
I think I can just do it with Mr. Martin or whoever handles it over email. Just want to make sure.
Okay,
Thank you.
That will be the exam date then.
Thank you.
No problem. Any additional matters for the record?
Nothing from the people.
Nothing from defense.
Thank you. You're all set, Mr. McCollum.
Okay, thank you.
You're welcome. Which matter is Mr. Abbott here?
Raphael Hanson.
Oh, he's not here yet.
I think, I believe that Mr. Hinton's in the jail.
Oh, okay, Mr. McCollum, you can log off. Hi, good morning, Ms. Dobbins.
Morning.
Which matter are you on?
I've got Carlos Clark. He's still in the breakout room. I just didn't
Oh.
have an opportunity to talk to him yet, but we have talked. And we do have an offer if you want to go on the record. But I'm just gonna ask that we keep the PE on and he'll make a decision then.
Good morning. Good morning,
Good morning, sir. What's your name?
Melvin Denson.
Very good. Heard you were here for some time, but you didn't start your audio, sir?
Ma'am, I thought I had it figured out, but I didn't get it right. I got it now.
Okay, excellent. Who is this attorney? Does he have one? Okay, let's see if we can track down your attorney for you, okay?
Yes, ma'am.
Let me close the breakout room so I can get this. Mr. Clark, can you hear me?
Yes.
Okay, excellent. We're on the record in the matter of the people of the state of Michigan versus Carlos Clark and file number 22-01749. Can I have your appearances, counsel?
Chris Martin for the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Carlos Clark, who's appearing by video.
Okay, let's see. Today's the date that was set for a PCC. How are we proceeding on this?
Your Honor, at this time, we do have an offer from the state if they would like to put it on the record, and we would be leaving the preliminary exam on for, I believe, August 5th, in order to give Mr. Carlos Clark the time to consider it.
Okay, thank you.
The offer of this is for Mr. Clark to participate in either a drug court or a sobriety court program, and upon successful completion of 1 year of that program, the people agreed to reduce the charge to either a misdemeanor or a full dismissal. I would just ask Ms. Donnelly, let us know before noon on the day before the exam, so that we're not bringing witnesses in if it is just going to be a clear.
Ms. Fallon, is that okay?
Yes, Your Honor, I will try to give him, that notice. Again, hopefully I'll have a decision by then.
Okay. And Mr. Clark, you heard the offer that was extended to you?
Yes.
Okay, so you're gonna continue this next court date to give yourself time to think about it. Do you have any questions for the court at this time?
No, I do not.
Okay. And this offer obviously expires at the time of preliminary examination?
That's correct.
Okay. Any additional matters for the record?
Nothing with the people.
No, Your Honor, thank you.
Thank you. You're all set, Mr. Clark. We'll see you next week.
All right. Thank you. Have a good day.
Same to you.
Thank you.
Hi, are you Ms. Robinson?
I am.
Okay, Mr. Benson, did you need to speak to him?
I think we're all set.
Okay.
Unless, Mr. Benson, did you have any questions for me before we get started?
No, ma'am, I don't.
Okay, great.
We're on the record in the matter of the people of the state of Michigan versus Melvin Benson, file number 22-01875 FD. Council appearance.
Chris Martin for the people.
Aaron Robinson, Assistant Public Defender for Mr. Benson.
Thank you. Today is the date that was set for a probable cause conference. How are we proceeding on this?
Your Honor, it's my understanding after speaking to Ms. Robinson that that Mr. Benson would like to avail himself of the sobriety court program. We've already confirmed he's eligible for the program. So at this point, we need to effectuate the transfer to get it to Judge Buchanan.
Wait, he's been screened?
I believe he's been screened already.
He hasn't from my end.
He might, well, I got an email from Ms. Strauss that he was eligible. I don't know if that means he was fully screened or not.
Okay, if you got an email from Ms. Strauss, then please put it in the screen. Let me double check and see. I'm usually included on those emails.
She said preliminary.
No, it says he needs to be referred for a screening appointment. So we will reset this because he has to be screened first.
Okay.
Okay, so Mr. Vincent, because you are seeking to be entered into the sobriety court, what we're going to do is we're going to set this for another hearing because you need to, or another probable cause conference, because you need to be screened for eligibility. Our records reflect that based on the charge, you're preliminarily eligible, but you still have to undergo a screening. So because of that, I'm going to find the cost to go beyond the 21-day time frame to reset this to have you screened, okay?
Yes, ma'am. I'm gonna find a pencil so I can write down my next court date.
Very good. I think it's very good.
Do September 2nd at 8:30 for the PCC.
Does that work for both?
I'm sorry, what was it?
September 2nd
September 2nd at what time?
at 8:30.
Yes, that will
For
work.
exam or PCC.
PCC.
Okay, I'm all set, ma'am.
Okay, it'll be September 2nd at 8:30.
September 2nd at 8:30.
And then I may have a new exam date.
Okay.
Do you have any questions today, sir?
No, ma'am, I don't.
You're gonna go ahead and reset your exam until September 9th at 8:30.
Oh, September 9th instead of the 2nd?
No, the second is gonna be your new probable cause conference, which is what you're here for today.
Okay,
Okay,
And
I'm
then-
just setting, I'm setting the preliminary examination for the 9th, which is the
Okay.
following week, but hopefully you won't need that, because if you're eligible for the sobriety court, then you'll be getting transferred over to Judge Buchanan's docket, okay?
okay.
Okay. Do you have any questions?
No, ma'am, I don't.
Any additional matters for the record?
Nothing from the people.
Nothing further from defense.
You're all set, Mr. Benson.
Thank you.
Okay, thank you. Everyone have a good day.
Same to you.
Yeah, sorry for the confusion. It said preliminarily eligible. So I was,
You know, every specialty court has a different definition.
I told him that. I said, you know what I need? I need a cheat sheet for,
Right.
because some want to be transferred beforehand. Some want you to take the plea and then transfer.
Yeah.
oh, yeah.
So I'm like,
I know, I can never remember.
give me a cheat sheet for these specialty courts, so I don't do it wrong.
Everyone have a good day.
Same to
Thanks.
you. Okay, Mr. Hinton is in custody. Are they gonna put him on?
I believe he's in custody.
Yeah.
What about Mr. Harrison?
Awesome.
He's representing himself, so
He doesn't have an attorney listed.
I thought he was, I thought he requested for a joint counsel last time he was here. He did. Mr. Benson, you're free to go. There should be a red button.
I'm
that
trying to
says
power
leave.
off now.
I'm powering
No
off now. I'm
worries, sir.
trying to power off.
No worries, sir. Mr. Abbott? We find out, Garrison hasn't come. We've made some calls to the jail as well as an email. They've not been very clear as to why Mr. Hinton was not placed on Zoom at 8:30, but they said that they'll get him on in 15 minutes.
Okay,
You apply for court appointment. Last note.
Also, do you have any update for us as to Percy Harrison? He applied for a court-appointed attorney last week.
Percy Harrison, let me check, Your Honor.
Thank you.
Your Honor,
Yes.
in regards to Percy Monty Harrison, date of birth 11/20/76. He
Okay,
refused
sounds
to, during arraignments, he refused to speak to the attorney and just kept winking at her. So she never got.
I recognize that, but because he stood mute at his arraignment. But
Okay,
last week during his PCC, he had changed his mind. He came
Okay.
upstairs, he spoke, and he said that he wanted to request court-appointed counsel. And so I found good cause to adjourn it, so that he can have an application completed. I
All
thought
right.
that there was an attorney in here that helped him that day.
well, that may be, if that application was submitted this week.
No, it was on the 15th. That should have been the 15th of July.
Oh, wow. I don't know. I'll have to look and I'm banished here due to COVID, Your Honor, so I don't have as much contact with my colleagues. as I
Oh, sorry.
do. But I'll get a hold of Mr. Cornish and see what he can find out.
Okay, sounds good. Thank you.
Thank you.
Good morning, sir. What's your name?
Andrew Simmons. Oh,
Okay. Who's in the jail?
Raphael Hinton, Your Honor.
Okay, thank you. Mr. Abbott, did you need to speak to him?
Yes, please.
Okay, I'll put you in a private meeting room. And then who's in their car? What's your name, sir?
Simmons.
Andrew Simmons?
Yes, ma'am.
Okay, Mr. Simmons, we're still waiting for the attorney to appear for a show cause, okay?
Okay.
Nick, what's the Zoom ID?
876-493-1931.
Exhibit sticker. You have an exhibit sticker?
Yeah.
Sorry. Just one. You grab one from me too, Chris, please. Sure. We get a defense one too.
Just one?
Two, please. So are you are introducing evidence?
I'm gonna ask the court to take official notice of
You want to mute that?
With water. I can hydrate it out here.
Is your client here? Oh, yeah. Still got some time, right? He's got a little time. Yeah.
Well, my guess. It just seems to me. I mean, circumstantially, yes, it's because the piece of mail.
Nothing of jail, right?
Yeah.
It was on the room that appeared to be his room.
It appeared to be the room only because there was a piece of mail sitting next to it. He was also claiming that they were looking to get out of there because there was no electricity and.
Functioning.
Yeah, I see that. Yeah, I know it was next to the bed. And he's kind of.
What am I supposed to do with it? Man?
I don't know, man. There's no.
It's not like this first time. Like, well, keep me out of jail. You know.
What can I say? Yeah, I know.
Okay.
Like I say, you know. Mail all over the house. How do you have it in?
You know, we gotta take guns seriously. Like, it's like one thing that we gotta take it seriously, and it is like something that we're trying to be conscientious about.
Totally understand that, but you get a guy with a piece of mail that doesn't necessarily just.
Bedroom, like it looked like he was living in that. He was living in that location, and
He was living in that location, there's no question about that.
so there's guns there.
Claiming that he didn't even know his guns were.
Okay, well then that's something, I guess it's an argument for trial. You know, it's
All right,
like I don't think.
I do just think this is a simple trespass because it plays with red tag. I think he told me they were coming back there to get some stuff, and he also told me the police were there like 3 or 4 times, which doesn't say anything before, so.
Well, how does he feel about if we can come up with some kind of a one-year misdemeanor with forfeiture of the guns? Can you do that?
He might. He might.
That's what we've offered Mr. Bond here. Now we have to lay a factual basis for the underlying offense. So
I don't know, I'm trying to think of something. The only thing I've thought of is, like I said, I mean, I know it's a 30-day, but like on the property and.
I don't think you're trespassing, but I think like improper transport of firearm, attempted proper transport, that's like 1 year. Even though obviously it's not in the car, you can lay a factual basis for the felony possession and have the benefit of that being. So it'd be a gun offense, but it's 1 year, keeps it and save no front jail view. Well, for guns.
You know, I get a lot of these, and I know a lot of these are like, one that guy has a gun.
Well,
CCW all day long.
People are getting shot all over town,
I understand.
and there's definitely like racial bias in police, and we want to make sure that like we're being fair in the process. So if we start making exceptions all the time, we can't.
All right. Well,
Yeah, it's something. It would be a legal fiction.
I'm sorry. Well, if I didn't mean to, I wouldn't have.
I wasn't trying to be rude. So what's the argument here?
So, so Trying had a CPR suspended because there's no suspension of license.
So, what's that?
So you're saying like it's basically a legal impossibility of.
Yes.
That was yesterday.
Surveillance is supposed to be found.
Yesterday we had.
It's about maybe. Those two procedures and protocols to obtain.
Yeah, here.
License is intact.
I mean, I don't mind. I just, came over here.
All right, well, I'll let you bring the argument up. I think we probably need more time to brief it, like. But,
Yeah, I understand.
No, I just happen to think of it all here.
What else you got? So you got 2 guns this morning. What else you got?
that's it. Here's some Jeff's.
The majority of the cases. That's correct. Used to say 90% of the cases have to do with alcohol or drugs. Alcohol and drugs. Yeah. Mike, I guess you're talking.
You're fine.
I gotta have a computer that's Celine custody LINA 211332. Eat out. I don't know. Yeah, he said they set it on the, looks like they said, changed it on the 18th. And they never even crashed. Yeah, all right. Not that I really do that. Sure. Yeah, it would be nice to know. Oh, yeah, I hear you. I got you. Something will come up or I'll get in trouble. You're good.
Or something.
Monday or whatever that is.
I don't know, he's paying another attorney, so maybe.
Yeah, well, he's paying, what's his name?
Okay,
Yeah.
I'll go back and find out.
You guys feel the same way.
Mr. Abbott,
Yes, sir.
were you all set with Mr. Hinton?
Yes.
What was the plan for him, sir?
We're requesting a preliminary exam
substitution.
Just want to leave it on for exam for next week.
Yes.
What's up with my bond?
Mr. Hinton, you're all set, sir. We're going to see you next week for your preliminary exam here in person at the court, okay?
Excuse me, Your Honor, may I ask a question?
I'm not the judge, sir.
Oh, okay, yes, sir.
I'm sure you could ask your attorney your question, though.
Yes, sir.
You want me to raise the issue of bond, Mr. Hinton?
I mean, if he's not the judge, yeah, sure.
So we'll wait. Mr. Bigelow, when the judge gets back, we'd like to raise the issue of bond.
Okay, thank you.
Thank you.
On the record in the matter of the people of the state of Michigan versus Raphael Deshawn Hinton, file number 22-01866, council appearance.
Chris Martin for the people.
Good morning, Your Honor. John Abbott representing Mr. Hinton. We both appear by video today.
Okay, they gotta track the file down. Today was a date that was set for a probable cause conference. My understanding is that we're continuing to exam, but you want to address bond.
That's correct, Your Honor.
Okay. I'm gonna have to wait for someone to bring me a file. Who's running today?
They have a lot of check boxes they have to do. They have to do a lot of check boxes.
Okay, you can proceed with your bond motion.
Thank you, Your Honor. It's my understanding that Mr. Hinton has an alternate place to live. He'll be living with his grandfather at the address on North Crest Road. That I know there's an allegation that the tether wasn't working, but it's just a matter of getting that charged and making sure it's working. The protected party can continue to be protected by court order. I'd ask the court to consider releasing him on bond pending the hearings that are scheduled for next week. Thank you.
Your Honor, I wonder if Mr. Abbott has the second violation in his file. There was a second violation. I'll email it to you.
Yeah, there was a second violation.
Would you like me to email it to you, John?
Sure, thank you.
How does my lawyer
Okay. Second violation alleges contact with the victim or the alleged victim. And so their bond motion is denied.
Thank you.
Any additional matters for the record?
have?
Nothing for the defense.
All right, we'll see you next week,
Thank you.
Mr. Hinton.
If you're my lawyer, how come you don't have the motion? I mean, you don't even know what I'm charged with or nothing, like, you don't even know the second allegation or anything.
Just because I didn't
So
say it
you
out
were
loud
arra-
doesn't
you
mean I
were-
don't know what it is.
You were arraigned, sir, yesterday. So you know what the second allegation is. Mr. Abbott wasn't present for your arraignment.
Thank you, Your Honor.
We're gonna forward him that document now, but you're free to go, Mr. Hinton. Sounds good. Mr. Brunette, how are you?
Good. How are you, Judge?
I'm doing well, thank you. I made it back. So that was
Good.
that was good.
Yeah.
And you met privately with Mr. Simmons. Are you all set, or did you need another date?
We would like another date. We came to a good resolution on a wage assignment, but we'd like a control date for Mr. Simmons to send us some documents. We're hoping to receive his pay stubs from his new employment once he starts to get them, and then his tax return, if he can find it. So we were thinking maybe 30 days out. If that's acceptable to the court.
Okay, that's correct, Mr. Simmons. You did discuss a wage
Yep.
assignment.
Yes, ma'am.
August 29th at 1:30.
Does August 29th at 1:30 work for you?
Yes, sir.
Yes.
Okay, we'll set the control date for that. Do you have any other issues today?
I have one other case, but for this case, I'm all set, Your Honor.
Okay, thank you, Mr. Simmons. You're free to go.
All right, thank you. Have a good day.
You're saying that to anybody else.
I know.
No, you're saying Mr. Simmons, to anybody else other than Mr. Simmons.
Did sound a
That
little-
was awkward. Okay, and then Mr. Brunette, your other 10 o'clock has failed to appear, so we can do a bench warrant.
Okay, thank you, Your Honor. The current balance on Miss Olson's debt is actually $812. I'd like to request that there be a cash bond in that amount so that perhaps she could pay off the debt by paying the bond.
812.
Yes, Your Honor.
Okay, very good.
812 and 23 cents, if it matters.
Well, we can only do whole numbers on the bond, so I'll do 813.
Okay, thank you.
Okay, sounds good. Thank you.
Okay, thank you, Your Honor. Appreciate
If
it.
I may be,
Thank you. Have a good one.
You
if
too.
I may be heard on,
Okay, let me call the case. Okay, sounds good. Mr. Harrison has refused to leave his cell. We're gonna continue to. PCC stands mute. I mean, preliminary examination, because he's probably got to be brought up right first. Stands. mute.
I'll be left on for next week.
We'll leave it on for next week. Okay, and I just did Hinton. We're on the record in the matter of the people of the state of Michigan versus Ryan Bond, file number 22-00981. FY council appearance.
Chris Martin for the people.
Jackie Mossborn on behalf of my client, Mr. Ryan Bond, who is standing to my right.
Okay, today was the date that was set for a preliminary examination. We were waiting for the officer to appear. It was supposed to be set at 9:30. Is your officer here yet?
Your Honor, he is not here. I can provide an explanation and an estimated time of arrival. As the court correctly stated, was set for 9:30. We subpoenaed 2 officers to be here today. One is Officer John Cosme. The other is Officer Vanderwerth. Officer Cosme is on a period of leave right now and is unable to appear. And so we have to make today's case entirely with Officer Vanderwerth. Yesterday afternoon, I informed our witness unit that we needed witnesses to appear for this case. Based upon our communications with Officer Vanderwerth this morning, he was not added to the witness list, but we called him just before 9:30 and he began driving over here from his home in Grand Rapids. As of a few moments ago, I was informed that he is within 20 minutes of the courthouse. He is prepared to testify today. We are prepared to proceed today. it was a miscommunication on our part, but we believe it's in the interest of judicial economy to allow the case to go forward. This morning, we only expect one witness. It will be relatively brief testimony. And, you know, I will do everything I can to keep it as concise as possible.
Well, I'm not clear what the miscommunication was because it sounds like you did speak to him. So why wasn't?
Well, I didn't speak to him yesterday. I spoke to our witness unit and said to call him in as a witness.
Okay.
And there was a miscommunication between, and I haven't seen this, but he says that according to their computer interface, he was not listed as somebody to come in. That was what he said at 9:30 when we called him. But we still told him to come, and he is driving from Grand Rapids to be here this morning, and he is prepared to testify. He's, you know, I don't think he is trying to avoid court today by any stretch. I think it was an honest miscommunication.
And with all due respect, Your Honor, if I may, I would object to the granting of any more time. Our previous preliminary examination was scheduled for June 16th. At that time, it was adjourned because Officer, I apologize if I'm saying his name incorrectly, but Officer Cosme was unavailable to testify at that time. New notice were issued to both parties, so we were well aware that, you know, we needed to be here today. We were here on time and ready to proceed, and if the state is not able to proceed, I would ask that the court dismiss this matter.
This is a case that has had so many steps to adjourn. It's a step to adjourn on, well, it looks like originally. It must have been an offer extended. A defense requested more time to think. So then it was set for May 20th, step to adjourn. And May 27th, step to adjourn. It says by defense attorney received discovery late. Not really sure what's going on here because it looked like there was already a offer extended. So was there a substitution of attorney on this?
No, I've been counsel since the beginning, Your Honor.
There was a supplemental discovery request because I don't understand how it said receive discovery late when there was already, it said, and defendant request more time to think a week prior to that. Nonetheless, we reset it for June 16th. We indicated if there was a reset, I do see there was a step to reset there. And then July is when it was reset again. There was a COVID quarantine step. Well, it looks like we had to give you some grace on these too.
In regards to, we have been trying to resolve the issue. In fairness to the prosecution, we have been negotiating back and forth, and we've been unable to reach a agreeable resolution to this point.
Okay. You said the officer lives in Grand Rapids?
Lives in Grand Rapids, and he was in his home when we contacted him.
Okay, and he's about 10, well, at this point, he should be 15 minutes away.
That would be my expectation.
Okay, I'm gonna allow 15 minutes only because it doesn't sound like my 10:30 is here yet, or that we're gonna run. I can't run 2 exams at 11 o'clock today.
I understand, Your Honor.
So
we have made a misdemeanor offer in this case as well.
we'll see if he appears in the next 15 minutes. And then Mr. Rothstein's client still has some time, so. Oh. We're on the record in the matter of the people
This is something.
of the state of Michigan versus Ryan James Martell Bond. File number is 22-00981 FY. Council appearance.
Chris Martin for the people. Before we begin this exam, I believe Mr. Rothstein had requested to call Mr. Moore's case.
Mr. Moore here. It's only been 18 minutes.
Jackie Moss, speaking on behalf of my client, Bond, is standing to my right.
Okay, today's the date that was set for an exam. Are you ready to proceed?
We are, Your Honor.
Any preliminary matters?
No, Your Honor.
From myself, Your Honor, yes, I would like to, ask the court to take judicial notice of two documents. The first of which is a personal protection, ex parte personal protection order that was issued against my client. And secondly, the Michigan Court Rule MCR 3.705, specifically subsection A, subsection 2. I've labeled those documents as Defendants Exhibit A and Exhibit B respectively.
Okay, any objections to the exhibits?
Well, I do think there's a foundation issue, especially as it relates to the conduct alleged. I think he's trying to backdoor in some evidence without actually putting on evidence. So if he can provide a sufficient foundation that this was something that was available to the officers involved on the side of the road, this is something they were aware of, and these are the only PPO documents that are out there, then we'd be more comfortable with it.
I'm still not understanding how PPO ties into one count of carrying concealed weapons, but I'm sure you guys will explain that to me.
Yes, Your Honor, in regards to my response to Mr. Martin. So MRE 201 states that the court can take judicial notice of adjudicate facts. The kinds of facts, a judicially noticed fact must be one that is not subject to reasonable dispute, in that it is either generally known within the territorial jurisdiction of the trial court or capable of accurate and ready determination by resort to resources whose accuracy cannot reasonably be questioned. I believe that PPO is an official court document you can't reasonably question. So therefore, I believe it falls within the scope of documents which this court can take judicial notice of.
Okay, why is it relevant?
Mr. Bond was cited for carrying a concealed weapon, Your Honor. Mr. Bond was a CPL holder. His CPL was suspended because of this PPO.
Okay, so that's the evidentiary value to show that he had a CPL that was suspended.
The evidentiary value, Your Honor, is I'm going to argue that this PPO was invalid because this PPO did not meet the MCR, the requirements set forth in MCR 3.705.
You want me to hear argument as to the fact that the PPO was invalid?
Your Honor, yes, I'm arguing that the PPO was invalid. Therefore, Mr. Bond's CPL should not have been suspended at the time. Therefore, there's no CCW.
Was the validity of the PPO argued at the circuit court? Because we don't issue PPOs.
Actually, there is an appeal pending regarding a tangent matter.
I'm not making a ruling on the circuit court's PPO validity. Or notice that that you determined it to be invalid. You can't determine it to be invalid. The court has to determine it to be invalid.
Yeah, Your Honor, and based on the MCR, it's
I see your argument. I see what you're saying.
Yeah.
You got to take that MCR
Okay.
to the circuit court and argue it there. I'm not making any determinations on that.
Your Honor.
Okay. Any other preliminary matters?
I think it might be wise to go ahead and place our misdemeanor on the record and give Mr. Bond an opportunity to reject the offer. We've offered him to plead guilty to an added count of attempted possession of a loaded firearm in the vehicle in violation of MCL 750.227C bracket A. That's a 1-year attempt with a maximum fine of $1,250. Kilbrook is going to jail. It's my understanding that Mr. Bond wishes to reject that.
Okay, that's correct. Your client wants to reject the offer, correct?
That is correct, Your Honor.
That's correct, sir. Okay. And that offer expires at the beginning of this exam. You recognize that? Okay, very good. Can you double check and make sure Mr. Moore is not here? Are we just waiting for, you just waiting for a bench warrant? You don't go on the record for those. He's not here. You're free to go. I'm gonna issue a bench warrant. I just sent my court officer to double check the hallway. Okay, you can call your first witness.
You will call Officer Zach Vanderwerf.
Right here. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
I think you can have a seat. If you can state your first and last name and spell them both.
Yes, ma'am. Officer Zachariah Vanderwerf. It's ZACHARIAH. Last of Vanderwerf, that's VANDERWER.
Proceed, counsel.
Officer Vanderwerf, how are you employed?
I employed with the Lansing Police Department,
And what's your role with the Lansing Police Department?
road patrol officer,
How long have you been a road patrol officer?
5 years.
Were you a road patrol officer on November 11th, 2021?
Yes.
Just say briefly what a road patrol officer does.
So we take 911 calls for service. When we have time, we also do proactive police work like traffic stops, for instance.
Okay, and you were on duty on November 11th, 2021,
Yes,
working in road patrol
yes,
in the evening hours?
yes,
At some point, did you find yourself in the area of St. Joseph and MLK?
yes.
Where is that located?
That is located in the city of Lansing County. Illinois.
State of Michigan?
Yes,
All right, and while you were in that location, did you come upon a Toyota Camry?
yes.
Anything stand out about the Camry?
I had no license plate on it.
Okay, were you in a marked patrol car when you came into contact with us?
Yes,
Anybody else in the car with you?
yeah, Officer John Postman.
Okay, did you initiate a traffic stop?
Yes.
Okay, what happened after the traffic stop?
We initiated a traffic stop. The vehicle was slow to stop. Typically in our training experience, when the vehicle is slow to stop, it could be someone that's hiding contraband or potential dangerous weapons. Officer Kozmak approached from the driver's side. I approached from the passenger side, making contact.
Did you learn anything about the driver of the vehicle?
The driver ended up coming back with a warrant.
All right, and when the driver came back with the warrant, what did you as the police officers on the scene do?
Officer Kozmak had the driver step out and he brought him to the back of his patrol vehicle, or our patrol vehicle. And then I stayed up with the passenger.
So you made contact with the passenger.
Yes,
And were you able to, did you ask the passenger what his name was?
yes.
What name did he give you?
Initially, it was Ryan Johnson.
Okay, did you later find out that that was not his real name?
Correct.
And did you later get his real name?
Yes,
What was his real name?
Ryan Bond.
All right, and if you saw Mr. Bond again, would you recognize him?
Yes,
Do you see him in the courtroom today?
I do.
And can you please point to him and identify an article of clothing he's wearing for the record?
Yeah, he's wearing a blue face mask.
Sitting next to his attorney at the council table.
Yes,
For purposes of the preliminary examination, may the record reflect that the officers identified the defendant.
Any objection to identification?
No objection for purposes of this proceeding only, Your Honor.
Identification is noted.
At some point, did Officer Cosme return to the vehicle where you were talking to Mr. Bond?
yes.
What happened when Officer Cosme returned to the vehicle?
He began to question him. I remember him asking him if he still had a
An
seat.
objective, Your Honor.
The response to the objection.
I think that there's a couple of reasons why this is not hearsay. One, the answer to an officer's question is adopting the premise of the question and is an admission on the part of the defendant in a case like this. And that's the evidence that we're seeking to elicit here.
You're asking him to tell what the other officer asked in the other officer's absence.
Yes, but,
Why is that not hearsay?
well, if he's adopting if he's answering the question and adopting the premise of the question, I would say that's an admission by the party opponent.
The response would be, he's about to tell me what the officer asked.
Yes, and there's no context for the answer without the premise.
Is this information being offered for the truth of the matter asserted?
It's being offered to talk about why they continue their investigation. So that's the other reason why I believe that it's an appropriate question at this point in the proceeding, because we could rephrase and start over, but I
think there's a way for you to get the information if he heard the answer without eliciting the hearsay. I'm gonna sustain the objection.
Okay. Based upon answers from Mr. Bond, did Mr. Bond say anything about a firearm in the vehicle?
Yes.
Okay. And based on what Mr. Bond said, what information did you learn about a potential firearm in the vehicle?
Well, after him advising that there was one in there, he ended up pulling down his pants to show me that there was a firearm placed between his legs.
Okay. Now, I'm going to show you an excerpt from your body worn camera that we have. I know we reviewed it briefly when you first arrived, but first I'm just going to ask you if you recognize it. I wish to share my screen in Zoom. Do I have permission to do that here?
You may.
As for audio, should I use my computer audio or does the audio?
Before you share, did you click share sound as well? You might have to exit out the share and do it over because you have to click share sound before you share screen.
Thanks. Officer Vanderwerf. Officer Vanderwerf, do you recognize this excerpt that's on the screen?
Yes.
What is this screenshot showing?
Well, this is my body cam footage from that traffic stop, and I'm standing on the passenger side.
All right, this is on November 11th, 2021.
Yes.
This is how things appeared on that day.
Yes.
Do you recognize the individual seated in that passenger seat?
Yes.
And is that Mr. Bond?
Yes.
And that's how he appeared when you made contact with him on November 11th, 21.
Yes.
All right, at this point, we move for admission of the camera footage.
I'm gonna object to identification based on what's showed there on the screen. We see the portion of an individual with a hat. There's no facial recognition. There's no way, or based on what's shown on the screen, for the officer to make that identification.
Okay, he's not using this to make identification though, but he's saying, I think the question was, is that how he appeared on that date? So we can rephrase it, but I can have him rephrase the question.
Please, and I'm trying to log in so I can get the video. I didn't know he was gonna do that, so I I may have misheard what I.
Okay, okay, can you,
The question was, is this
Clarify the
how
question.
scene appeared on the data, and this is how Mr. Bond appeared?
yeah, it's not you being used to identify.
Okay,
him.
I understand.
Oh.
this one. Okay. Thank you.
Okay, so objections overruled.
So I'm going to move for omission of this video clip as People's Exhibit 1.
Any objection to it being admitted as people exhibit 1?
No objection, Your Honor.
Okay, people exhibit 1 is admitted.
That there's gonna be insurance on this, but that's a secondary thing. But if you're honest with me right now, dude, if the firearm.
Can you hear that?
I can hear it. Whether or not I can understand what they're saying is a different question. I can hear it.
I don't need to take you to jail. I just need some honesty, okay?
Okay, listen. I don't wanna go to jail.
I got you, brother. I'll work.
Okay, listen, hold on, listen.
Yep.
Hold on, listen. Hands are here.
No, I'm good, man.
Hands are here.
You see, we're both comfortable,
Okay,
relaxed.
Now listen, okay, now listen, I'm gonna be honest with you. Okay, okay, I do got my phone. I'm not, like it's legal, like it's in my name.
It was last time too.
Yeah, you know what I'm saying? I kind of got this little PPO little thing going on. I'm not supposed to have it on my person.
Okay, I'm telling
You know what I'm saying? But listen though. You know what I'm saying? We good. I don't like no 60 girl, none of that, bro. I'm clean.
Trust me,
I ain't got no drugs.
Listen.
You can trust me.
Listen, okay?
Oh, hey.
For the safety aspect of it.
Yeah, I'm about to say you can take me out the car. Yeah, bro.
Okay.
Yeah, y'all say here.
Okay, just leave it right there.
Oh yeah.
No.
Yeah,
Just
here, bro. I ain't reaching.
Okay.
Here. Grab it, bro. I ain't
Thank you.
doing nothing. Yeah, yes.
Did that clip show an accurate portrayal of your interactions with Mr. Bond on November 11th?
Yes.
When you first made contact with him at the window, were you able to see a firearm?
No.
Were you looking for a firearm?
Typically on traffic stop, we are always trying to make sure that we are looking for one.
You were able to see one?
No.
And then when you asked Mr. Bond if he had a firearm, what did he say?
Is that in reference to the question that Officer Postman asked him?
Well, when you were at the side of the road with him, what did he say about a firearm?
He did say he had one.
Did he say anything about a personal protective order?
He did.
What did he say about that?
He said he had a PPO situation.
And what was his understanding of, based on what he said, what that PPO meant for his ability to possess a firearm?
That he wasn't supposed to have it on him.
And then you said he pulled down his pants?
Yes.
When he pulled down his pants, what did you see?
I saw the magazine of the firearm.
All right, and did you take that off this person at that point?
Yes, I removed it from him and then cleared it and made it safe at the back of the vehicle.
And did you check that firearm into evidence?
I don't know if it was me specifically or if it was Officer Postman that did.
Do you recognize that photograph?
Yes.
What is that a photograph of?
Of the firearm.
That's the firearm you seized off of Mr. Bond on November 11th.
Yes.
Move for admission of People's Exhibit 2.
Any objection?
No objection.
People to admitted.
All right, people, no further questions.
Thank you. Cross-examination. And are you gonna use this video at all?
Yes, Your Honor.
Okay.
That's easier, that's fine. I started at, just for the purposes of preserving the record, I started at 6 minutes through 7:31 on the video. So that's the excerpt I intend to admit, 6 minutes through 7:30.
Thank you.
Sure. I'll let you.
Thank you. Morning, officer. Good morning. you testified that, strike that, let me refresh, review these before I go to another question. Isn't it true, officer, that during the course of your investigation, you entered Mr. Bond's name was searched through your computer system in the lien? Yes. Was that you or your partner that conducted that lien search? I do not recall.
Exit full circuit somehow. And then we can drag here. Yeah, gotcha. Is that better? Yeah. For purposes of the record, let the record reflect that I'm getting ready to play for the officer video beginning at the 25 minutes and 45 seconds mark.
No bond, arrest only. Okay, because
I'm gonna rewind that just a little bit.
You said 25 minutes.
Yes, Your Honor.
And what second, Mark?
I'm going back a little bit.
Okay.
Okay. I'll start, just to be safe, I'll start at the 24 minutes and 33 seconds. And before I hit play, officer, just to verify, we're still looking at the footage from your body camera? Yes. Okay. Thank you.
Boston 21 on me. Everyone file when you're ready.
Go for it.
Gonna be a last of Bond. It's gonna be Boy, Ocean, Nora, David. First of Ryan, Robert, Yellow, Adam, Nora. Middle of James, Martell, James dash Martell. So James, common spelling, dash Martell, which is Mary, Adam, Robert, Tom, Edward, Lincoln, Lincoln, Edward. Black male, date of birth is 7/13/1992. The warrant. So he said he's got to call. He's got to call our command because typically with warrants, because your warrant, even though it's a felony, it says no bond, arrest only. Okay, because typically they set bonds for everything, right? But for yours, it says no bond.
I'm gonna pause. Officer, do you recall who you're speaking with at this particular junction in the video?
I don't remember his name, but it was the driver of the vehicle.
And just to be clear, that was not Mr. Bond.
No.
Okay. I'm gonna continue playing.
Arrest only, okay? So he's got to make a call, all right? And he's got a lot of pull since he's got a lot of time on him, and see if he can help you out. So we'll see what happens. But it's kind of in the hands of our command at this point. Yeah, because we have a lot more leeway with stuff that have bonds on it and stuff. So like say, hey, it's got like $100 bond, $200, $300, $400, $500 bond. We got a lot of leeway with that kind of stuff, but yeah. Well, we don't know that yet. We'll see.
911 information only.
Go ahead.
Your subject Ryan James Martello Bond, date of birth 07/13/1992, has a PPO that is not served protecting a Barbara Moore Garrett out of Lansing. He also has a second person with search order not served protecting a Kai Garrett out of Lansing. That seen this record is valid.
Let me pause here. Obviously there's a lot of different speakers here and that would be hearsay. And so we'd object to the admission of anything from that. Also, as a point of clarity, the evidence we offered was the 6 minute through 7:30 mark on the video. I understand that he can play portions of the officer's statements and what he observed, but for none of this is in evidence at this point. Is our position.
Yeah, and just to be clear, Chris, and for the court's record, the portion of the video that I'm looking specifically for, we haven't got to yet. I know it's within this time frame. I couldn't tell you exactly where it was. My computer, with my notes, or my video rather, where it's earmarked, was still logging in. So that's why we're using more stuff. But it's coming up.
Okay, well, I'll just turn that volume down here because I think we're disturbing before it crosses the hall.
Okay, let me resume playing now, Your Honor.
Are you trying to still locate the area of the portion that you want admitted?
This is the general proximity of the video. I'm guessing it's within the next minute and a half to 2 minutes or so.
Oh, okay.
10-4. Yeah, we're probably gonna have to serve them. They said they're not served.
They're not served? Okay. Are they gonna come to me?
I gotta get a hold of them because I ran him through lane just so they could tell me. So now I'm just gonna have to call them to.
So what are you thinking now with this embezzlement? This is something he said he's in the court with. You know what I mean? I know it's a fine.
Saying no bond, arrest only too.
Alright, that's what
he thinks he's already going anyway. 21, can you also run a firearm serial number? Okay, it's gonna be Boy Sam Charles X-ray 394. Boy Sam Charles X-ray 394. It's gonna be on a black semi-automatic Glock. And it's gonna be a 9mm.
The first number.
Oh, okay, yeah. Okay, I got him.
Hey, we're taking the gun now, right?
Yeah.
And then you want me to call the jail to get him served then? Hey, I gotta, so your PPOs, your PPOs are not served, so I'm gonna have to call up to our jail and they're gonna have to serve you over the radio, okay? So they'll just...
Hold on, so my CPL is still valid then, right?
You have to have the copy. You have to have it with you. And you have to
have it with me?
Correct. You have to have it and present it to an officer if you are carrying a weapon. You have to have it no matter what. So it's a technicality right now. So
but is it a crime?
Yes, it is.
Oh,
here's the thing. So you've come in and you present
Can you just put that in the call for me?
valid CPL. Where is it?
I've been off that
Awesome. Hey, did we check his CPL status? I never checked his CPL status.
He says he's got one, but it doesn't matter. He can't produce a hard copy of it. He's supposed to let us know upon contact.
Yeah, he didn't, and he also didn't.
So I guess, officer, I'll start with a question here. Your question in regard to your interaction with Mr. Bond and stated that the previous clip shown to you by the prosecution was an accurate representation of your interaction with Mr. Bond, correct?
Yes.
And it was during that interaction where Mr. Bond referenced a PPO, correct?
Yes.
And now in this portion of the video, there is, you're discussing that you had a conversation with Mr. Bond in relation to his PPO, correct?
Yes.
I'm sorry, in relation to his CPL, correct?
Correct.
Okay, and would you agree that that conversation contradicts the previous part of the conversation? Meaning, at one point, initially, Mr. Bond stated that there was a PPO, there was a PPO in relation to his CPL. At a later portion, there was discussion in regard to him having a valid CPL, correct?
Correct.
Okay.
Yeah, he didn't produce a hard copy.
Denied it, and I asked him if he had it, because I knew that he was a CPL. Well, I knew that.
But then, but he's got valid ID, right? So that's the problem.
At that point, dude, right, we're asking why the stop took so long.
Yeah, I got you.
But he's, like I said, last time I had contact with him, he was just as decent, you know what I mean?
Yeah. So you want me to check it or no?
Yeah, go ahead, check it, yeah. I guess that's there, but.
Shoot, what did I do with it? 7/13/92. Unlawful offense of the pistol.
To ensure safety, peace officers.
And then do I need to type anything in or no? Notice of suspended CPL. Not be dis.
Yeah, because.
Okay. I can't hear that. We got people like behind the door, we're not going to know that they're there, and they don't want to answer the door. We're just playing over the speaker. It's just like, all right, you're served. Like,
That's not him. That's
try to play it, but
Oh, wrong person.
it just comes down to that. So, how long you been playing for?
Right here.
So,
Yeah, he's
you
got
get
one.
that wave. We're just going to.
Yeah, it's right up there.
Is that one?
Yeah.
You get this straight up.
Yeah, so he's good, dude.
Not serve verbal notices. Suspended CPL. License suspension 9/2/2021. Not serve verbal notice of suspended CPL license by police officer.
Oh, shit. So, do we need to serve, let him know?
Okay, officer, are you able to hear, and is your memory refreshed as to what's going on at this specific juncture of the video?
Yes.
Okay. Is it? So right now you're looking at the computer screen with the information regarding Mr. Bond's name in the lien system, correct?
Yes.
And isn't it true that that information revealed to you that, I guess, two things, I'll break it up. I'll say, one, that Mr. Bond had a CPL, and two, that the CPL was suspended. Is that correct?
Yes.
Okay. And actually, I guess it revealed a third thing as well. Isn't it true that the lien system revealed that Mr. Bond had not been served notice of suspension of his CPL?
Yes. It said the date that he was suspended, but it also said not to.
Oh, that his license was suspended, his CPL license was suspended?
I think so. That's how I'm reading it.
Yeah, let's give him verbal notice anyway. Not know that's been, because, yeah, he has the domestic on it. Domestic on this.
Oh, good save. Yeah, I gotta let him know that it's suspended.
Yeah, just let him know.
Okay.
Okay, so I guess for purposes of this proceeding, Your Honor, I would propose to admit the section of the video beginning at the 31-minute mark to where we're at right now, 3310. That is the portion that contains the video snippet that I just had the conversation with the officer regarding him running Mr. Bond through the lien system.
Oh, any objections? to
No objection.
that? Okay, that portion will be admitted.
Lastly, officer, one other, I don't want to skip ahead to.
Hey, my apologies, it's Vanderworth again. So he also has a suspension on his CPL license. So he's also been served that as well. He's aware now that all right, thank you. Yeah, I can hear you. Can you hear him okay?
Yeah. All right, Mr. Bond, it is ordered for them to have contact with a Barbara Hundred Hillary Kiger. You are not to follow or appear within sight of the petitioners. You are not to appear at their place of workplace or residence. You can't enter onto property owned or leased by the petitioners. Can't threaten to kill or physically injure the petitioners. You are also prohibited from purchasing or possessing a firearm. Both these orders are in effect. And they're in effect until March 5th of 2022. And enforced by Judge Garcia thereafter.
You got all that?
Yeah.
Okay. All right, thank you.
Perfect. What's your location?
We're right in front of 1318 West San Joseph.
Sweet. Thank you, sir.
Yep, thank you.
So the PO is
Officially in place now.
effective right now?
As of right now, and until that date that he said in March of like 2022, it looks like.
Okay.
I got it up front. Yeah.
So
When I know exactly what you're asking.
Yeah,
I've got your number.
Okay.
So let me. Can I kill my body camera real quick and have a side conversation with you?
Yeah.
And did you let him know about his CPL? So I can make sure they change that? Yeah. Okay. Boston 21. Yeah, so for Ryan Bond, when I looked him up, it looks like he has got a CPL suspension. So I served that to him. So he's aware now that that is suspended. Just so you can change that in there.
Okay, I apologize, officer, but I guess I missed the portion, but you just referenced it. So isn't it true that at some point during your interaction with Mr. Bond, you in fact served him with the notice of the suspension of his CPO license?
Yes.
Officer, I'm not aware of this, so as far as the information that you see in lien, does that provide to you any information specific to the PPO itself?
Not sometimes. It all depends on a PPO versus like a bond conditional. Sometimes they will tell us what the things are that they're not allowed to do. But other times you will have to call up to the jail so they can read off a hard copy of what they are allowed or not allowed to do.
Okay. And do you recall in Mr. Bond's lien record, for lack of a better term, was there information pertaining to his PPO?
No.
No, there wasn't, or no, you don't recall?
No, so as far as looking on the computer, there was no information as far as that was concerned. I didn't hear of any of that information until the detention officer read it over the phone.
Got you. Okay. And is it fair to say that your interaction, strike that. Is it fair to say that Mr. Bond was cooperative with you and your partner during the investigation that evening?
I would say yes, he was cooperative.
You stated that the firearm that was recovered, that was revealed to you by Mr. Bond, correct?
Yes.
Okay. When you went to retrieve the firearm, I believe I heard you say this, there was, it's your testimony that the firearm was concealed on this person. You could not see any portion of it.
I could not see any portion.
I guess the last thing I'll clarify with you, officer, for the record. So in addition to Mr. Bond not having notice of the suspension of his CPL, isn't it true that lien also revealed that Mr. Bond had not been served with the notice of his PPO?
Yeah, it said in lien that he was not served his PPO, but he knew of it. So that was what was confusing.
Lien said he knew of it, or are you saying he said he knew it?
He said he knew of it, but lien had not said that he was served.
Your Honor, I just want to get clarification in regards to judicial notice of the PPO. I understand your ruling earlier, and my purpose for asking is not in regard to that. Is this taken judicial notice of? Can I show the officer?
I'm sorry, I didn't take judicial notice of it, so what are you trying?
Correct,
to
yeah, I'm sorry,
Okay.
that's where I was getting clarification.
Okay, but are you now seeking to use this as an exhibit? Is that what you're trying to do?
Either an exhibit or, well, I guess judicial notice, because I don't have foundation to utilize it as an exhibit. I like to take judicial notice of, again, not the portion that was discussed earlier, but specifically the what was ordered or prohibited in the terms of the PPO. The actions that Mr. Bond was prohibited.
Your Honor, I think I don't mean to interrupt, but I think we're at the same foundation problem that we were before, because there was a reference in the body camera to multiple PPOs. And so we do need a foundation to know like what we're referring to here and if this is the operative document. I
just think it would, well, I don't know why you don't think you can use, is this the same PPO that you're saying he was served at the scene?
Yes, Your Honor.
Okay, why can't you admit it as an exhibit to this witness? And question him about it to lay the foundation.
Because my understanding is because the officer is not aware of the, trying to think what I heard in the recording. I guess I take that back, Your Honor. The recording did I can lay foundation through this witness.
Okay, thank you.
Officer, do you recall the name or names of individuals who, the petitioners in either of the PPOs that were issued against Mr. Bond?
I do not recall.
Would it like to go back to portion of the video that discussion took place at?
Seven 1392. An unlawful offense of the pistol.
To ensure safety.
And then do I need to type anything in or no? Notice of suspended CPL. Should not be this.
Yeah, because
Okay. I don't hear that. No, man. We got people like behind the door. They're not going to know that they're there, but they don't want to answer the door. We're just playing over the speaker. It's just like, all right, you're served. Like,
that's not it. That's
try to play it, but
Oh, wrong person.
it just comes down to that. So, how long you been playing?
Right here.
So,
yeah, he's
you
got
get
one.
that waved. We're just going to.
Yeah, it's right up there.
Is that one?
Yeah.
Yeah, so it's food.
Not serve verbal notices, suspended CPL. License suspension 9/2/2021. Not serve verbal notices, suspended CPL license by police officer.
Oh shit! So do we need to let him know that his license was suspended? CPL license was suspended?
I think so. That's how I'm reading it.
Yeah, let's give him verbal notice anyway. Let him know that's been because yeah, he has the domestic on it. Domestic on this.
Oh, good save. Yeah, I gotta let him know that it's suspended.
Yeah, just let him know.
Okay. Last of Bond, so Boy, Ocean, Nora, David. First of Ryan, Robert, Yellow, Adam, Nora. It is 4. Have those on them, and then what's in there isn't what's in there.
Oh, yes,
But
cool.
You've got what's in there.
Oh, yes, cool. Yeah. Shit, like, bro, I just left Walgreens when y'all got us. I'm like,
okay.
Yeah, I just left Walgreens.
You want me to just put you on speaker? Yeah, thank you.
So the PPO is
officially in place. You need to step away from me. Yeah, I can hear you. Can you hear him okay?
Yeah.
It is ordered. We're going to have contact with a Barbara Hundreds.
Officer, were you able to hear the name that was relayed to you?
I'm struggling to hear it. I think it said Barbara, but I couldn't catch the last name.
Okay. I'd like to show, Your Honor, may I approach to show the witness proposed exhibit A? Officer, do you recognize the document that you're looking at?
Yes,
What do you recognize it to be?
it's a personal protection order.
And who is listed as the petitioner in the personal protection order?
If I'm reading it right, it says Barbara Moore Garrett,
And who is listed as the respondent?
Ryan Bond.
And based on your recollection, is it your belief that the PPO in front of you is the PPO that was referenced in the body cam discussion?
I believe it to be.
If you look down toward the bottom under the actual order, there's several boxes. Those boxes are what prohibits the respondent from doing certain actions. Do you see the portion I'm referring to?
Yes.
And
At this point, I'm just going to object. I think the document speaks for itself. If he was not the one who issued the document, and I don't know what the utility of having him read the document into the record is.
So he's already said that that's based on his understanding, the PPO that was referenced. So are you moving to admit that as an exhibit?
Okay, yeah, thank you, Your Honor. At this time, I would move to admit the defendant's proposed exhibit A into evidence.
Thank you. Any objection?
The same foundational objections that I had earlier, that there were referenced multiple PPOs, and he said he believed it to be the PPO. I don't know if that's necessarily the, but he didn't say with any certainty.
Well, I'm not going to require any certainty. He said he believed it based on his understanding. He's reviewed the document. He had an opportunity to say he didn't believe it was, or he could have just said, I don't know. But he said he believed it to be the one. And so based on that, I will grant your request to admit it.
Okay, thank you, Your Honor. Okay, officer, so you're looking at now what is exhibit A. Is there a box under the order?
I think there was already an objection.
Yes, the document speaks for itself.
The document
Okay.
speaks for itself, so we're not going to have him testify. He didn't issue this document.
Okay.
Okay. You can publish them.
Fine, I guess. Nah,
Can you get that for me, Mr. Bigelow? Thank you. You can proceed.
Okay, yeah, thank you, Your Honor. At this point, Your Honor, I do not have any further questions for the officer.
Okay, can you read that right?
Your Honor. Officer Vanderwerf, you said that Mr. Bond was cooperative, but you also said that he gave a false name when you first asked for him to identify himself.
Yes.
Would you describe him as cooperative throughout the entire course of your interactions with him?
Not the entire, and at the very initial stages, he wasn't very cooperative. He didn't really want to provide a date of birth and he gave me a false name.
And just to be clear, you ran his name and CPL through your lien system, is that right?
Yes.
And when you ran the CPL, what was the status of the CPL that you saw in the system?
Suspended.
Nothing.
Thank you. May this witness be excused?
Yes.
Thank you, Officer Vanderwerf.
Thank you.
Okay, are you calling any other witnesses?
People restroom.
Are you calling any witnesses?
No, Your Honor.
Chief argument?
We're asking for bind over on the complaint as charged. The defense's argument seems to be that that Mr. Bond didn't have notice that he was suspended. However, he had knowledge that he was suspended. When the officer initially made contact and asked about the gun and discovered that there was a gun there, he said he wasn't supposed to have it because of a domestic situation. And he had an understanding that he was suspended based upon the things he said. And we can get into the technicalities. I do not have the code in front of me here, but I believe that what we have is that there is probable cause to believe that he had noticed that he was suspended based upon his statements to the officer and admission that he shouldn't have a gun on his person at the time that he made contact with the officer.
Mr. Marks.
Yes, thank you, Your Honor. The exhibit A that was.
Oh, you might want to stop.
Sorry.
Sure.
Sorry about that.
Exhibit A is a PPO against Mr. Bond. The court had the authority and ability to prohibit Mr. Bond from engaging in a number of activities or actions. One of those was to purchase or possess a firearm. On the PPO, on its face, that box is not checked. That's in contradiction to the information that was read to Mr. Bond at the traffic stop when he was served the PPO. So I think that, first of all, Mr. Bond made contradicting statements himself during the police interaction. In the beginning, there was an acknowledgement by Mr. Bond of a PPO situation he referenced, and he also seemed to reference not being able to carry a firearm as a result thereof. However, later on in that same traffic stop, Mr. Bond engages in conversation with that same officer in reference to him having a CPL. So Mr. Bond was clearly, there was clearly I think based on the contradicting statements, it's clear that Mr. Bond did not know the exact status of his CPL at the time. Furthermore, Mr. Bond is being cited for carrying a concealed weapon. Mr. Bond's CPL license grants him the ability to do that exact thing that he's been charged with. However, due to the PPO, that license was suspended. Mr. Bond had no knowledge of the suspension. Therefore, in his mind, he was not breaking the law that evening and had no way to know that he was breaking the law until the officer served him with notice of suspension of his CPL that evening. For those reasons, I would ask the court, in the interest of fairness to Mr. Bond, in the interest of justice, I don't see how the court can hold Mr. Bond responsible for a crime for which he had a license to do the exact behavior which he is now being cited for.
There was a date that was set for a preliminary examination. At the time of preliminary examination, the burden is on the prosecution to establish probable cause. So for your information, Mr. Bond, is the prosecution's requirement and burden to establish that there's a probable cause that a crime was committed, insufficient probable cause that you were the defendant who committed the crime. That burden is not to be compared with the burden that you would face if you were to proceed to trial. Trial, the burden is on the prosecution again, but it's for beyond a reasonable doubt. This is a burden here of more than just mere suspicion that a crime was committed. The court is the sole determiner of credibility. I make a ruling based on the information presented at the hearing today. I also get to weigh the probability or likelihood of the government's ability to establish guilt at the time of trial. Okay, so today we heard the testimony of one witness, that being Officer Zachariah Vanderwerth, stated that on the date of November 11, 2022, during the evening hours at the area of St. Joseph and MLK, a traffic stop was effectuated on a Camry, Toyota Camry, for no license plate. He identified the defendant, who's present here in the court, as the individual who was the passenger. Stated the individual gave a different name, furnished the information of Ryan Jackson. It was later determined his name to be Ryan Bond. During that interaction, this officer that testified, Vanderwerth, stated that he made contact with Mr. Bond, and Mr. Bond admitted to having a firearm. We heard the video, which was admitted by People's Exhibit 1 as the body cam of the officer, and that body cam demonstrated a conversation between the officer and the defendant I heard the defendant state to the officer on the video that I got my gun. I do got my gun. It's legal. I kind of got this little PPO thing going. There were some areas or portions of that communication that did become a little bit inaudible. I don't know if it's because the defendant turned his head the opposite direction or if it was the way it was being recorded. I'm not sure. But the defendant did indicate to the officer that he had a CPL and that his gun was legal. He shared some other information about him not having drugs. The officers engaged in a conversation after going and searching into lien based on the exhibit submitted through the cross-examination. It was determined by the officers that the PPO was not served. Officers were asked that they should check his CPL status. It says that he was not served with the status. Well, they said he wasn't served with the status of the CPL suspension, and so that we should do it now. There's also, I think, concern, I guess, when they shared that with Mr. Bond, he became concerned. And the officer said, you know, I get it, you know, there's some technicalities and I can explain something further to you. There was another officer on the phone who I guess was the one serving by phone the PPO on Mr. Bond. And then we heard the officer say, so the PPO is officially in place now. Based on that transaction, I don't see how there could have been probable cause sufficient that a crime was committed because the PPO was not served nor was notice of a suspension served until after the traffic stop. We're going to serve it now and then we're going to hold you accountable. We're going to put the cart before the horse in this situation. And I recognize in this situation, it looks like the officers were unfamiliar with how to handle this themselves. So this may be the first time they dealt with something like this. Also, admitted here under Defendant's Exhibit A is a copy of the proposed PPO that he was being served. I do distinctly remember the officers discussing a PPO from a March 2022 day, which this PPO does state that on here. That it will be in effect until March 5th, 2022. The court ordered many things in this PPO, and it indicated that by checking what would be prohibited under this PPO, I see that purchasing or possessing a firearm is not checked on this PPO. So based on that, I don't believe there's sufficient probable cause this case will be dismissed.
Thank you, Your Honor.
Here's your exhibit.
Yeah.